In this lesson, we're going to go over our case brief for Lucy v. Zehmer. This is a Supreme Court of Virginia decision from 1954. So if you want to follow along with me as I work through this case brief, simply visit studicata.com/case-briefs. And from there, you can just search Lucy v. Zehmer. This case should pop up. You're just going to click that. You'll be good to go if you want to follow along with me as I work through this case brief. So just for some quick background, though, before we get into the facts here, this case centers on the objective nature of mutual assent as a requirement to formation of contracts. So for this case, we really just want to understand the difference between objective and subjective tests. This is really going to help us understand the court's decision in Lucy v. Zehmer, but it's also going to help us understand as 1Ls in law school, whether we're in torts, contract law, criminal law, understanding the difference between objective and subjective tests is going to be really beneficial. Okay, so in terms of contract law, though, we understand to form a contract, we really need two big things. We need mutual assent between the parties, and we need that mutual assent to be supported by consideration. When we have mutual assent and we have consideration, that gives us a traditional enforceable contract. And we understand that mutual assent is really just a meeting of the minds. It's an offer and acceptance. And so this case, Lucy v. Zehmer, is really exploring, well, what is a true meeting of the minds? Is this a meeting of the minds in a more objective way or a more subjective way? And what we mean here in terms of objective and subjective, when we say objective, like the court is using an objective test, the court is looking at the outward words and actions of the parties. Basically, how would a reasonable person interpret the outward words and actions of the parties? So basically, every time you hear the word objective in law school, you should think objective, outward, objective, outward. Objective means we look at the outward words and actions of the parties involved. When we hear subjective, you should think inward, right? Sin, S-I-N. Subjective, we look inward. Subjective, we look inward. Meaning we look at basically the hidden, honest intentions of the parties. What are the people involved actually thinking in their heads, honestly? Objective, we look at their outward words and actions. Subjective, we look at their hidden internal intentions. Okay, and we know, as we'll see in Lucy v. Zehmer, sometimes these two things don't always match up. What a person's outward words and actions are, what they're manifesting outwardly through their words and actions may not align internally to what they're thinking. And that's kind of what we get here in Lucy v. Zehmer. Important to recognize, something to keep in mind as we jump into the facts here. When we're thinking about mutual assent as a requirement to contract formation, we need a meeting of the minds. This is an objective test. This is really well established in contract law. When we're trying to determine whether we have a meeting of the minds, we have a true offer and acceptance, we look at the outward words and actions of the parties, not their hidden internal intentions. Okay, it's an objective test. With all of that in mind, let's just jump into the facts here for Lucy v. Zehmer. Defendant A.H. Zehmer and his wife Ida Zehmer owned a 471.6 acre tract of land in Virginia known as the Ferguson Farm. Plaintiff W.O. Lucy had known Zehmer for many years and had previously shown interest in buying the farm. Years earlier, Zehmer had orally agreed to sell the farm to Lucy, but Zehmer later backs out of that deal, which takes us to December 20, 1952. Lucy visited Zehmer's restaurant, bringing a bottle of whiskey. Lucy and Zehmer drank together and discussed the sale of the farm for 30 to 40 minutes. During the conversation, Zehmer drafted an initial sales agreement for the farm on the back of a restaurant receipt for $50,000. Lucy looks at the receipt, asks Zehmer to rewrite the agreement because it was written in the singular. Lucy wanted Zehmer's wife, Ida, to also sign the agreement, which Zehmer obliges to this. Zehmer obliged, and both Mr. and Mrs. Zehmer signed the written agreement, this rewritten agreement on the restaurant receipt. Zehmer later claimed that his wife had hesitated to sign, but did so after he assured her that he was joking about selling the farm. Okay, so these are like the key facts, right? So basically, we have the Ferguson Farm, 470 acres. It's obvious that Lucy wants this farm. Years before the night in question in this fact pattern, we know that Zehmer and Lucy had orally agreed to sell the farm to Lucy, but Zehmer kind of backs out of the deal at the last second. So it's obvious Lucy wants this farm. And that takes us to December 20, 1952. Lucy goes to Zehmer's restaurant, brings a bottle of whiskey. They talk about selling the farm over 30 to 40 minutes. During the conversation, Zehmer drafts that initial sales agreement. Lucy looks at it and says, yeah, this is pretty good for $50,000. However, I want your wife to also sign this. Zehmer says, okay, rewrites the agreement to have his wife on it too. They both sign this rewritten agreement. So Lucy thinks at this point, great, I'm getting the farm, finally, Ferguson Farm for $50,000. So the following day, Lucy told his brother, JC, about the purchase, and they hired an attorney to examine the title. Attorney confirmed the title was clear, and Lucy wrote to Zehmer asking when they would close the deal. This is when Lucy learns the bad news. Zehmer replied, insisting that he had never intended to sell the farm and that the note was written in jest. Ultimately, Zehmer refused to sell the farm to Lucy, and Lucy sued for specific performance. Lucy is saying, we had a contract. I'm suing basically for breach of contract, demanding specific performance of essentially this title transfer. Look, I just want this deal to go through. I'm going to pay you $50,000 and I want title to the Ferguson Farm. Zehmer testified that he was too intoxicated for the agreement to be taken seriously and that Lucy should have recognized this. However, at no point before the agreement was signed had Zehmer indicated to Lucy, either through words or actions, that he was not serious about selling the farm. Ultimately, the trial court held that Lucy had not proven his right to specific performance, leading to the dismissal of the case. Lucy appealed the decision. This goes to the Supreme Court of Virginia, where the central issue was whether a written agreement, purportedly made in jest, constitutes a binding contract enforceable by specific performance in court. The Supreme Court of Virginia reverses the trial court's decision, holding that the agreement constituted a valid and enforceable contract that required specific performance by the Zehmers to sell the Ferguson Farm to Lucy. So Lucy wins here. The Supreme Court of Virginia says this is a valid and enforceable contract, even though the Zehmers are claiming this was all a big joke. This happened in a restaurant bar over some whiskey. We wrote it on this receipt, at the restaurant. This wasn't a serious intent on our part to sell the Ferguson Farm for $50,000. Supreme Court of Virginia says none of that matters. We're going to say this was a traditional enforceable contract. Okay, so Lucy is entitled to the Ferguson Farm for $50,000 as agreed in the contract. So how does the Supreme Court of Virginia arrive at this decision? Well, the court reasoned that the outward expression of intention in the agreement indicated a serious transaction despite Zehmer's claims of jest. The court emphasized that the law assesses agreements based on the reasonable meaning of the parties' expressed intentions, not their unexpressed internal states of mind. So the court says here, look, in determining whether we have basically mutual assent, in determining whether we have a meeting of the minds, a true offer and acceptance, we look at the outward words and actions of the parties, not the subjective hidden intentions. I think the key fact here is, remember, at no point before the agreement was signed had Zehmer indicated to Lucy, either through words or actions, that he was not serious about selling the farm. Basically, the court here is saying all of the outward words and actions that were manifested by the Zehmers indicate serious willingness to sell the farm for $50,000. Basically, there's no way a reasonable person, including Lucy here, could have interpreted the outward words and actions of the Zehmers to mean that they were joking, that they weren't serious about their intent to sell. Basically, had the Zehmers indicated to Lucy, hey, look, this is all a big joke. We don't actually want to sell this to you for $50,000. Haha, but we'll sign this as a big joke. Like maybe that's then different, right? Because then their outward words and actions would be expressing that they're not serious about selling the farm. But based on what actually unfolds on that night at that bar, there was never a manifestation outwardly by the Zehmers that they weren't serious. And the court says we don't care about the subjective hidden intentions. It doesn't matter what the Zehmers were thinking in their own brains as this was all unfolding. It's what their outward words and actions demonstrated. And the court points out, look, this was a 30 to 40 minute long discussion. There was negotiations. Lucy even asks them to rewrite the agreement so that both sign. Remember, there's the initial draft, but it's written in the singular. So Lucy asks Zehmer to rewrite the agreement to include his wife. And then Zehmer and his wife both sign the rewritten agreement. The court says all of these things indicate outward willingness to enter into the agreement. How is a reasonable person looking at all of those facts supposed to know that internally you don't actually have the intent to sell the farm, right? How is a person like Lucy supposed to look at all of these outward words and actions and reasonably interpret that you're joking, that you're not serious? So the court says for all of these reasons, basically leading up to the execution of that written agreement, the outward words and actions objectively manifest willingness to enter the agreement on the Zehmer's part. Therefore, that is mutual assent. That's a valid offer and acceptance. It's supported by consideration. That's a traditional enforceable contract. The key takeaway from this case should be it's an objective test. We don't care when we're trying to decide whether there's a meeting of the minds, whether we have an offer and acceptance between the parties. We only consider their outward words and actions, not their subjective hidden intentions. That is Lucy v. Zehmer. This is a Supreme Court of Virginia decision from 1954.